Turning to the sources of contract law, first of all, it's important to understand that contract law is mostly common law. It's mostly judge-made law. So if you think back when we were talking about the sources of American law, there's very little about contracts in the Constitution. There's very little about contracts in federal statutes. There's not even that much in state statutes, except through the Uniform Commercial Code. Most of it is through common law, but it has been codified in something called the Restatement of Contracts. And the Restatement of Contracts is written by a scholar, so it is not itself law, but it is meant to summarize what judges have been saying generally over hundreds of years in interpreting contracts. And so it ends up having some of the force of law. As I mentioned, other aspects of contracts, specifically having to do with goods and the sale of goods, has been enacted as part of the Uniform Commercial Code and then put into state statutes all over the country. And so those have been adopted into state law. Now, what is a contract? A contract is a legally enforceable promise. That means it has to be something that's promised in the future, not something that's immediately executed. It can be oral or written. It can be express or implied based on people's behavior and course of dealing. And you can even have what's called a quasi-contract or an implied-in-law contract. And this is an idea of a contract where you're claiming, well, we didn't have a contract, but if you don't give me certain kinds of money, you will be unjustly enriched by our course of dealings and by the way you behaved. And so some restitution is required. We'll talk more about quasi-contracts, unjust enrichment, and restitution in a little bit. You can also have unilateral contracts. Unilateral contracts are contracts where the act of acceptance itself is the act of performance. So for example, if I say, I will give you $100 to clean my house, you don't accept that contract simply by saying, yes, I'm going to clean your house. I don't give you the $100 for that. I give you the $100 for actually doing the cleaning. And so the act of performing is the act of accepting the contract. Now, it's important to understand certain contract law terms. The promisor is the person who makes the promise. The promisee is the person to whom the promise is made. And in contracts, you generally have reciprocal promises. And so each person is both the promisor and the promisee with regard to certain aspects of the contract. So I will give you something and you will give me something else. We are both promisors and promisees. There's also the possibility of a beneficiary, which would be a third party who benefits from the promise that's created. And remember, when we are talking about people, promisors, promisees, beneficiaries, corporations are also deemed persons for contract law purposes. As I mentioned a minute ago, most, though not absolutely all, contracts involve reciprocal promises by both parties. Now, it's important to understand that in forming contracts, there has to be some mutual assent. Both parties have to exhibit the intent to be bound. It's what we sometimes refer to as the meeting of the minds. So both parties have to understand it as a contract and treat it as a contract. And they have to have this intent to be bound by what it is that they said. It can't just be sort of a casual, oh, it would be great if you did X. That's not demonstrating an intent to be bound. Now, the intent to be bound is determined by objective criteria. What would a reasonable person understand by what somebody said or what somebody wrote, and whether there's an intent to be bound. It's not just based on what one of the parties thinks, it's based on what a jury or judge or finder of fact determines would be reasonable under the circumstances.